All right, well, we've heard from private practitioners, we've heard from public servant, and now we get a chance to hear from in-house counsel. Christina Schaefer is General Counsel for Fishback Financial Corporation, which is the holding company related to First Bank and Trust and other financial subsidiaries. And prior to joining FFC, she worked in private practice. So she's had both the outside counsel and in-house counsel experience. She is active in the South Dakota Bar Association, but also American Bar Association, Women in Law, South Dakota's Bankers Association, Legislative Commission. And like many of the speakers today, has a heart for charity also, with school-based mentoring program and Girls on the Run. So let's welcome Christina Schaefer.
Worried that I wouldn't be able to see over the podium, so step one accomplished. I'm here to talk today about litigation, workouts, bankruptcy, and your clients and in-house counsel's perspective. When I'm talking, there might be an inclination for you to look around the room and wonder who I'm talking about. Let me assure you, though, that even as in-house counsel, I still have clients. The key difference, though, is I can't decline representation of my clients. And my clients are probably a little bit more likely to complain to me if they're upset with what I do. There are three major topics I'm going to cover today. The first is litigation, workouts, collection, and bankruptcy, and then the attorney-client relationship in general. So just as a couple of preliminary matters, does your client have a litigation policy? I think this is an important question to ask right off the bat. Your litigation policy might cover things such as billing practices. It might also cover things just to keep in mind in terms of managing the client relationship, such as when litigation is filed, does your client or whoever's managing that litigation have to make regular reports to the board? That way you can help your client in terms of complying with that policy. Does your client understand potential insurance coverage issues associated with the litigation? The first thing to ask is your client providing that notice to its carrier? And is it doing so in a timely fashion? Do you have clients who are actively looking for claims to be identified? Or does your client wait until that complaint is filed and before they provide notice to their carrier? Probably equally important, what are your clients providing to their carrier? And frankly, who's sending the bills to the carrier? If you, as an outside practicing attorney, are you billing the carrier directly? Are you billing the client and trusting that the client's keeping track of their retention amount? The other thing to keep in mind is, unless you tell your clients, they will forward whatever the carrier asks for in terms of information. By and large, that's probably not going to be a problem, but if there's a potential for a coverage dispute at some point, you might want to be instructing your clients what they should and should not be providing to their insurance carriers. What happens from an organizational perspective once litigation has been filed? This is particularly true, I think, in the financial institution context. If you work with a lot of financial institutions, there's probably a process, and they probably have some low-level person who makes $8 an hour handling things like garnishments, levies, requests from the government for financial information. Make sure that that person doesn't accidentally get the subpoena for a case that is being litigated and accidentally provide a bunch of documents to the other side without you having a chance to go through them. So I think it's just important that you understand organizationally what happens when litigation has been filed. Discovery. I'm not going to engage in a forensic evidence discussion today, probably much to all of your relief. But I do think it's important that you ask your clients whether they have an email retention policy and or a well-defined process for e-discovery. If your clients might have purchased an e-discovery solution. If they don't have an e-discovery solution, what tools are they using in Outlook or whatever emails company they're using in order to manage that litigation? If you haven't had a chance to discuss with your clients, there's some really cool features in Exchange 10 that allow you to go in and query people's mailboxes without those people knowing. It allows you to take snapshots, preserve that information. There's a lot of really neat features in Exchange 10 for you to discuss with your clients. What are the potentials for human intervention in this process? Not all companies are as fortunate as Fishback Financial to have internal counsel, but it's important to know at what point HR gets involved, at what point the employees potentially have the ability to manipulate that data. You know, at my organization, for example, when we go in to conduct e-discovery on the email system or whatnot, we have certain IT parameters that have to be met too, just because we're a bank and we've got all sorts of additional layers of security to make sure only people who need access have access. So just having those hard discussions with your clients about what the potentials are for human intervention in this process. How is the data collected and produced? You know, unless you're the one, you being outside counsel is going in and helping frame this up, know what keywords your clients are using when they search the emails. Know what they're telling people. You know, a lot of us talk a lot about email, but we all know there's still a lot of physical documents. Are we telling people, go see what you have saved on the network, go see what you have saved in your personal drive, go see what you have saved in your drawers? You need to understand how that data is collected and produced. Are physical documents properly maintained? You know, you can have the best email retention policy. People are going to print those emails because they don't like the fact that their emails delete after 12 months. So don't forget about the physical documents. And I think, you know, if you get sued, your initial reaction is to tell all the major players with the litigation you need to preserve the documents. But are you telling the janitor who has the keys to the storage locker so that the janitor doesn't accidentally get those boxes, see that they're old, dump them in the shred bin? Oh, that was unfortunate. There we go. And are there other policies that may interfere with your client's production? That's BYOD, not BYOB. If your client has a BYOB policy, I guess that would be a fun place to work. But you know, when you look at your client's email system, do the employees own their own devices? Are they allowed to bring their personal devices in and access company email on them? And if they is the company able to get that information off? If you work for a financial institution, there's a good chance the answer is yes. But not necessarily, not all the time. Similar with text messages. If that's a BYO, you know, if your employees get text messages on their personal cell phone, you know, you as a company, what are you doing? You know, are you advising your employee to not delete his personal text messages? So just things to keep in mind if you do have a BYOD policy at your company. So just observations from my perspective when it comes to litigation. Most clients don't understand the legal process. Hopefully they aren't in a position where they've been sued a whole heck of a lot. You know, if you have a client, don't tell them that you're going to file this motion for summary judgment. Hopefully after that it'll all be resolved. Unless you have a sophisticated client, they might have no idea what that means. So just keep that in mind. Public relations and staff communication. I don't think there's anything that strikes the fear into a client's heart any more than someone from the Argus Leader calling. You don't want to be a splashy headline. And when litigation ends up being filed, you need to be talking to your client about what their PR plan is. Not because you don't trust your clients, we have very bright clients, but because they might not know what to say when they get a call from the Argus Leader. So you need to make sure that they have a press communication plan, and same thing with staff. You might be telling, you know, in my case, my bank president, as someone calls, here's our prepared statement, here's what you can say. But what is that bank president telling the tellers? What are the tellers saying if someone comes into the lobby and says, I saw on the news X, Y, and Z, what happened? So keep in mind, public relations, staff communication, I know it's not your job as lawyers, but I think it does behoove you to mention that to your client when you're working on litigation. Alternative dispute resolution and settlement. Do your clients understand what a mediation is? The first time I went to a mediation, I sat there with the mediator and I hated him. And I couldn't imagine why my attorney thought this was a good mediator for the case. To me, he seemed kind of in my face, kind of gruff, seemed like he was on the other side's side. And I think that's probably a pretty normal reaction, depending on the mediator. It was a really good mediator for the case because it forced us to come to a resolution. But if your client doesn't have a lot of experience with mediation might be a bit of a shock for them. I think the other thing to keep in mind with alternative dispute resolution, your client probably believes that they're right. They don't believe they should pay anything. And when you tell them to show up to mediation, and by the way, when you leave here, we're probably going to ask you to be prepared to write a check, that can be a little bit shocking for your client as well. So make sure they have a good understanding when they walk into an ADR type of situation. Along those lines, the value of a case, I think it's important as an attorney when you're talking to your clients about the case that you're saying, you're not all along saying this is a $20,000 case, this is a $20,000 case, and then all of a sudden you have a $50,000 offer and you're telling your client to settle it. Just to be upfront and honest about the value of the case. For all you attorneys in here, the importance of privilege and how not to lose it. When you send documents to your clients, if they're privileged, you should probably remind them of that if you don't want that document being forwarded. This is true if you don't want it forwarded to 25 people in the organization. I can't tell you how many times it seems like you get a document and the natural reaction is to forward it. It may not be appropriate to forward it to the others. Along those lines, this comes up particularly in the financial institution or the creditor context. Is that a document you want your client handing over to their federal regulator, their state regulator? So just keep those kind of things in mind when you're providing advice to your client, is they might not understand how important privilege is, so you may need to remind them from time to time. And the closing of a litigation file. You've probably spent a lot of time telling your clients, don't destroy information, don't destroy information. When the file is closed, tell them when it's appropriate for them to destroy that file. Otherwise, it'll probably sit in Never Never Land to be destroyed, 20 years from now or something. So when a file closes, just make sure you're instructing your clients when they should close it and what they should do with those documents. Moving on to workouts, collections, and bankruptcies. From a debtor-creditor perspective, there's any number of issues that can trip up even the best clients. I work with some of what I consider the best loan officers in South Dakota, and so their reaction to me is when we have a problem, they say, well, just let me fix it, Christina. I'll just call my customer, we'll figure it out amongst themselves. We don't really want to pay another law firm, they don't want to pay a law firm, let's work it out. 9 times out of 10, that's probably a poor idea. Again, not because they're bad loan officers or they don't understand, but it's just not usually a good idea. The regulator made me do it. In today's heightened scrutiny of financial institutions, our regulators are telling us more and more often to show efforts at collections. They're going into our files and they're telling us to do things. You need to get an updated financial statement. You need to do this. The fact that they're doing that is actually confidential supervisory information. As a result, loan officers should not be sharing that with their customers when they're going out and saying, I need an updated financial statement. They can certainly go out and tell their customer, I need an updated financial statement. They shouldn't be doing so under the guise that the regulator made me do it. My customer insists that he's going to pay us back, reaffirm the debt, or make it right. For all you debtor attorneys, I am really sorry that I have to call and ask you this question. But our debtors are telling us, nope, I'll pay you back. I'll talk to my attorney, I'll pay you back. And my response is always, okay, I will call your lawyer and see if that's actually the case. And if that is, then we'll draft up a reaffirmation agreement. But I think it's human nature to say we're going to make it right with the bank. And so that's why I have to make those calls. I apologize. I understand you probably have not told your client that. What communication can we have with a customer in bankruptcy? I think by and large bankers are very worried about violating the provisions of the automatic stay. My guess is most banks, upon filing of a bankruptcy, code that loan so statements aren't sent. And the reason for that is because most vendors don't have the ability for us to put a statement message on there that says, this communication is not an attempt to collect a debt. So the easier thing for most financial institutions is just to turn off all notices. I understand that's not always easy then for debtors counsel. You're not getting regular statements that indicate the principal and the balance. You might not be getting other regular notices. Banks are by and large most happy to turn those on. We just want some sort of assurance from debtors counsel that they understand we're doing so for informational purposes, not in violation of the automatic stay. Lenders, I think, and bankers are just nervous. Creditors in general are nervous about getting in trouble for violating that stay. help me understand. These are what I find come across my desk as kind of what people are calling Christina Schaefer about on any one given day. And the first is reaffirmation agreements. They might not always make sense. At FFCI can do them. Sometimes I get the help of outside counsel. Your client might just immediately say, I'm going to reaffirm this debt, and you know what, it's for a $200 loan. Does that make sense for your clients? Not all of our lenders were here today to hear Mr. Gower talk about the foreclosure process from A to Z, but a lot of financial institutions and other mortgage lenders in the state, they didn't do a lot of foreclosures. I started in 2007. For those of you who were practicing then, that was kind of a bad time to break into banking, but it taught us a lot very quickly about the foreclosure process. A lot of lenders prior to then, a lot of mortgage companies, frankly didn't have a ton of personal foreclosure experience, so it's hard sometimes for people to understand. I think the question I get the most for people is the deficiency statutes, and I share the similar opinion that an appraiser is a good idea, but try to explain to a loan officer that you are going to foreclose on this person's house and therefore we should send an appraiser out right before we initiate the foreclosure action. It seems awkward to send an appraiser out to someone's house, ask them to look through in preparation for the foreclosure proceeding. So just make sure that you're helping your clients understand why that's necessary and what happens if that process isn't followed. The alternatives to disclosure or to traditional foreclosure, I think my biggest comment here, if you do a deed in lieu or a voluntary non-judicial foreclosure once, your client's going to remember that and they're really going to like it and they're going to want to do it again. Send your documents in Adobe, lock them. Do not send your documents to your clients to get signatures in Word. Your clients will copy and paste them and they will try to use them in situations that are not appropriate. Word has a really snazzy feature. You can go File, Save As, it converts it to Adobe. My only caution with that is that actually allows you to copy and paste the text from Adobe still into Word. So it's not a fail-safe, but just keep that in mind that those are great alternatives, but make sure that you're explaining to your clients in what situations those alternatives are appropriate, lest they use them in an inappropriate manner. Second mortgages. Keith mentioned this briefly as well. It doesn't always make sense for a lender to take out the first and foreclose. I think a lot of lenders, a lot of financial institutions have it drilled into their head that we should foreclose. It's not always the best course of action. So help your client understand when it makes actually more sense just to sue out the note. Chapters 7, 11, and 13 distinctions. No under reaffirmation can or can't be used. People will call up and say, my client's filed a Chapter 13, you need to do a reaffirmation agreement. It doesn't work. They don't understand what a Chapter 13 plan is. Hopefully if you have a Chapter 11 situation and you're a creditor, you're working with experienced counsel, so you shouldn't have a ton of questions. Hopefully they're not working on those alone. But just make sure that your clients understand the distinctions between a Chapter 7, 13, and 11. I receive that question a lot, particularly as it seems like there's more and more Chapter 13 plans filed. Bankers just aren't that used to working with them, so make sure clients understand the distinction. And last, the attorney-client relationship in general. Keeping your clients relatively happy, my attempt at humor at bankers doesn't. I'm hoping these tips are more than you get off of Google in terms of how to keep your clients happy. Appropriately measure your clients' time expectations. If you're working a lot with corporations, there's a good chance that they are used to working with a law firm and frankly one lawyer at a particular law firm. I work with a lawyer who gets back to me in a couple hours. I have to stop and mentally make a note if I'm working with another lawyer or another law firm that person probably doesn't have the same turnaround time. And at times it can get frustrating. So I think if you take on a new corporate client because of conflicts or maybe you just won their business, it's important to understand what their timing expectations are. We all know we're not your only client, but deep down we probably actually do think we are. Know your audience when providing advice. I don't care about Blue Book citation. I know it looks great, and it's a chance for us to be lawyers. I will tell you that if I have an executive, a board of director, or one of my senior management people, when they read long citations with Blue Book, they skip everything in there because all they see is the parentheses and the periods and the years, and they go straight to the end. Footnote, if you have case citations you feel like you need to include in your clients in a memo, footnote them. And never underestimate the power of an executive summary. I tell all law firms, I get that, and most of the people in my organization are going to read the first paragraph, the executive summary. They're going to rely on me to read the rest. If you don't put in an executive summary, they're going to flip to the back page and see if you have a summary at the end. If you don't do an executive summary, then I'm going to have to do one before I give it to our board of directors, because they just don't enjoy reading legal analysis as much as I do. The other thing along those lines, I'm not sure, although we all know about persuasive authority and things like that, I'm not sure that that's a principle of knowledge held by the general population. I would omit references to the Eastern Middle District of Tennessee and just say another court held, unless for some reason that court has some specific significance to the advice you're providing to your client. Pick up the phone. I think it's important to over-communicate, and I'll give you an example. I have a weekly loan committee meeting. Every week, for some of my files, I have a loan officer who sends me an email and asks me what's the status of this particular file. I would really like to know the answer ahead of time, instead of calling my lawyer who might be working on a collection case or some other case for me and saying, what's going on here? The other thing is that if you've given me a date, and this can be litigation, it can be collection action, but if you've given me a date that the default hearing is September 10th, I'm going to tell the people at the bank that the default hearing is September 10th or whatever, and they're going to call me that morning and ask me how it turned out. So to the extent that you provided me with a date, please make sure to try to follow up with me on that date. I know some clients probably have a preference as to phone and email. Someone told me once they deliver bad news via email, good news via phone. I don't worry so much about that. I just want to hear from you. Remember the difference between business decision and legal advice. Make sure your client does too. There are multiple times when there might be two perfectly acceptable legal solutions to a problem, and your client just needs to pick one. Just make sure you're clear with them whether the advice you're giving them is still legal decisions or whether they just need to make a business decision. Being out of the office happens. Clients need a backup plan. That backup plan, unless you have a really good assistant, isn't just your assistant telling you when you'll be back in the office. I run into it all the time. I'm a person of one right now in the legal department. I take phone calls when I'm out Mount Rushmore, standing on a bench trying to get cell phone service. And my loan officers, they get nervous when they can't get a hold of me. I haven't checked my cell phone today because I'm sure I have 10 missed calls. But you need a backup plan. I think particularly if you're a partner or if you're a sophisticated attorney, and let's just say you're the only one that client ever talks to, handing them off to an associate can be a little bit of a confidence shaker. And I was an associate. I'm sure I was confident enough to handle clients' questions. But clients don't always understand that. They look at this 20-something person hemming and hawing on the phone, and they wonder what kind of service they're getting. So if you're going to be gone on sabbatical or something like that, I think it behooves you to bring in that associate early or another partner early, just so that your client has some level of confidence with your backup plan. Details matter, especially when it comes to names and titles. In private practice, it's partner, it's associate. At the bank, there's a lot of vice presidents. There's a lot of assistant vice presidents, but it's kind of a big deal to us. There's a board resolution. When we get elected vice president, we get a letter from the president of the company. We kind of like our titles. So from time to time, check the signature blocks of the emails that you're getting from your clients and make sure you're using the right titles when you're sending them letters, when you're inviting them to things. Kind of along those lines, double check your bills, double check your pleadings. We don't want to see other clients' entries. We don't want to see other clients' names left over maybe a form letter that you've sent to us. Also, don't assume clients want you to look into a tangential issue. Ask. You might be looking at a loan file, you might be looking at an employment law issue, and in the course of your review of our materials, you might come across something and say, I wonder if they thought of this. Ask us that. Maybe we haven't, and if we haven't, I have no doubt we want you to take a look at that issue and give us a memo or give us more advice. But there's also a chance we've actually already looked at that. Maybe we have an opinion from another law firm, and we don't want to pay for that research twice. So before you kind of dive into a side note, I know a lot of lawyers, I think that's a value add. Look, here's this other point of legal advice I can provide too. I think it's great, but just ask before you do that. Conflicts happen, but we would prefer that they didn't. We have chosen law firms based on who we like to work with. I think when you get a call that someone can't help you because it's a conflict, people kind of go into panic mode a little bit. To the less sophisticated client, well, what does that mean? Does that mean you've already started helping the other side? Make sure your client understands what a conflict is. If you have someone you feel comfortable referring them to service, I think that's also a good point as well. Clients have billing pet peeves. Learn them early. Without picking out anyone, I'll give a couple of my pet peeves. Vague entries, or entries that I can't tie back to something. If there's a citation to review of, in Ray Jones to determine applicability to loan file,